An HOA that had been dormant for 7 years sent me a lien notice for $1,550. When I pulled the county records, I found out the election that supposedly revived it never had enough people in the room to be legal. The man who ran that election made one mistake he never expected anyone to catch. If a ghost HOA showed up and attached a debt to your home title, would you pay it and move on? Stay with me because I am going to answer that question at the end. Here is what I want you to see before we get there. The moment I read that letter and the 20 minutes of research that told me something was deeply wrong, the day a coalition of 11 homeowners walked into a county courthouse and made the case that every single one of those liens was built on nothing. And the afternoon, my attorney called me at my desk with a word that made 2 years of work suddenly feel very quiet. I am 54 years old, divorced 8 years now, cleanly enough that I do not wince when I say it. I work as a bookkeeper for small businesses in the Dallas suburbs, contractors, retail operations, a few sole proprietors who need someone to keep their books straight. Numbers are where I feel at home. I am precise about them the way some people are precise about grammar. A charge on an invoice without a clear explanation is something I cannot leave alone. That quality has cost me in some parts of my life and saved me considerably in others. I bought my house 9 years ago in a suburb southwest of Dallas, a modest 3-bedroom in a neighborhood called Hillcrest Commons, established in the 1980s, the kind of place where the trees have been growing long enough to make the streets feel like they belong there. I waved at my neighbors, I mowed my lawn, I paid my property taxes. I paid a PID assessment, a public improvement district fee that the city used to maintain the neighborhood entrance, the boulevard lighting, and a small common park. I had never paid a cent in HOA dues, never received a dues notice, never attended an HOA meeting. As far as I knew, and as far as most of my neighbors knew, the Hillcrest Commons HOA had quietly stopped existing somewhere between 6 and 10 years ago. Then, in April, the letter arrived. The man I will call Dawson had bought a house in the neighborhood 3 years earlier. He was organized and he was confident, and the first time I met him at a neighborhood event, he shook hands with the particular firmness of someone who expects to be remembered. Within a year of moving in, he had started making noise about the neighborhood's common areas. He had opinions about the entrance landscaping. He had concerns about the signage. He attended city meetings. He was, as people said at the time, very engaged. What he wanted, it turned out, was authority. The PID gave him no authority. That mechanism ran through the city, not through any individual. But an HOA gave a president authority. An HOA gave a board the ability to levy assessments, enter into contracts, and make decisions on behalf of homeowners, whether those homeowners had asked them to or not. He said, at one of the neighborhood gatherings that first year, "We have an existing structure here. We should use it. Why let all those original covenants sit dormant when we could be doing something with them?" I remember thinking at the time that it was an interesting way to frame community participation as something to be done to a neighborhood rather than with one. Before I tell you what Dawson did, I need to explain the legal architecture underneath it because this is where most people get confused, and confusion is exactly what he was counting on. Under Texas law, an HOA that has gone dormant but has never been formally dissolved by a court can technically be reactivated. It does not automatically disappear just because it stops operating. The legal argument for revival is that the original declaration of covenants, the document recorded with the county when the neighborhood was established, remains binding on all property owners in the subdivision, and that the association created under that declaration can be brought back to life. But there is a catch, and it is a specific, documented, enforceable catch. To reactivate an HOA, the people doing the reactivating must follow the procedures outlined in the HOA's own governing documents. Those documents specify exactly how officer elections must be conducted, what advance notice is required, by what method, to whom. They define what constitutes a quorum, the minimum number of eligible members who must be present or represented for any vote to be valid. If those procedures are not followed, the election is invalid, and if the election is invalid, then the person claiming to be president has no authority. And if the president has no authority, then every contract signed, every management company engaged, and every lien filed in the association's name is built on nothing. Texas law is also clear about what lien notices must disclose, what due process homeowners are entitled to before a lien attaches to their title, and what recourse exists through county courts and the state attorney general's Consumer Protection Division when those requirements are not met. This is the framework my attorney, Miss Kelly, had in her head from the day I first called her. I did not know any of it the morning I read that letter, but I knew something was wrong, and I knew how to find out why. So here is what I want to ask you before we go further. Have you ever received a notice from a company, an HOA, a landlord, anyone, that seemed official, seemed real, but something about it just did not sit right? And what did you do? Leave it in the comments. I am genuinely curious how many people felt what I felt reading that letter and what their first instinct was. I set the letter on my kitchen counter and read it twice. Then I did what I always do when something does not add up. I went back to the source documents. I pulled my closing file from 9 years ago, the title search, the deed, the disclosure statements. My closing documents showed no active HOA assessment at the time of purchase, which under Texas law would have been required to be disclosed if one existed. I called my real estate attorney from the original transaction. I said, I received a letter from an HOA claiming I owe dues. I do not recall any active HOA when I bought this house. She said, that's interesting. If the HOA was collecting dues at the time of sale, it would normally appear in your closing documents. Its absence is meaningful. I would pull the county records on the HOA entity itself, when it last filed, whether it filed for dissolution, and who is currently listed as an officer. I spent the next evening doing exactly that. The HOA was registered with Dallas County. It had filed annual reports consistently from its founding until 7 years ago. Then the filing stopped. No dissolution, no updates. Nothing until 6 months before my letter arrived, when someone filed an update listing Dawson as president and restarted the record. I sat at my kitchen table and looked at that gap. 7 years of silence, and then, suddenly, a revival. With no membership vote I had been invited to, no notice I had received, and a dues bill for $1,550 attached to my home title. I said out loud to no one, who authorized him to do this? That was the question that started everything. Open loop. By summer, Hillcrest Commons had become a neighborhood I barely recognized. 10 homes had liens. Every one of those homeowners was disputing them. Some had hired attorneys, some had filed city complaints. One household had a truck permanently parked in front of Dawson's house with a hand-painted sign that read, "Do not be defrauded." I understood the impulse. I felt the frustration alongside all of them. What I did not understand, what I tried to explain in the group text chain and the driveway conversations and the one tense neighborhood meeting where people talked over each other for 2 hours, was that the truck and the sign were releasing pressure in the wrong direction. You cannot park your way to avoided lien. You cannot shout your way to a refund. The pressure needed to go to exactly 3 places: the county courthouse, the city's legal office, and the Texas Attorney General's Consumer Protection Division. Those were the places where the question of whether Dawson's election was valid could be answered. Those were the places where a management company collecting dues on behalf of an entity that may have had no authority could be scrutinized. That was where the fight had to happen. Not on the street, not ever on the street. I said to my neighbor Patrice, who had become my closest ally in the legal work, "This is going to end badly if someone doesn't get a judge involved soon." She said, "The lawyers are moving as fast as they can." I said, "They need to move faster." They did not move fast enough. In early August, I heard gunshots from inside my house. A neighbor had opened fire on another neighbor's wife. She was shot multiple times. She survived, through what she described afterward as something she could not fully explain. Her husband, who ran to her when he heard the shots, also discharged a firearm. Both men were taken into custody. The shooter was charged with aggravated assault. I called 911. I stayed inside until the street was secured. And then I sat at my kitchen table and thought about how far a dispute over the validity of an election that put 18 people in a room had traveled. I want to say this once, plainly, and move on. Nothing, not a lien, not a fraudulent HOA, not 2 years of documented harassment, justifies picking up a weapon. There are courts, there are attorneys, there are regulators. Every one of those paths was available that morning. The man who chose differently nearly killed a woman who had nothing to do with any legal filing. It was not complicated, it was a tragedy, and it made me more determined to finish what we had started in the courthouse. The shooting accelerated everything. What had been a civil dispute now had a criminal backdrop, which meant the police were reviewing the HOA situation as context for the neighborhood conflict. They had already received multiple fraud complaints about the management company Metro Alliance. The shooting added urgency to a review already in progress. Now there were investigators asking the same question I had been asking since April. That is when the discovery process in the civil challenge produced the meeting records. Here is what they showed. The notice for the revival meeting had been sent by email to a partial list of homeowners, missing approximately a third of the properties in the neighborhood. The number of people who attended the meeting was 18. The neighborhood contained approximately 96 properties. The HOA's own governing documents defined quorum as 25% of eligible members. 18 out of 96 is 18.8%. The meeting had not achieved quorum. The election was invalid. Dawson's attorney disputed this. He argued that certain properties should be excluded from the eligible membership count for reasons that conveniently, mathematically, brought the 18 attendees just above the quorum threshold if you accepted every exclusion. Ms. Kelly challenged every single one. Then Patrice called me in October. She said, "The city told my attorney that the PID already covers everything the HOA was supposedly revived to provide. Maintenance, landscaping, entrance upkeep, all of it is already funded. There is no gap the HOA was filling." I said, "So the HOA was not revived to provide services?" She said, "The question is what it was revived to do, if not that." That question was the one the police investigation was also asking, and neither of us had to answer it. The court record was going to do that. The civil case reached its hearing. 11 homeowners, 1 coalition, 2 attorneys, and a record that stretched back to the founding documents of a neighborhood built in the 1980s. I testified. I brought my closing file, 9 years of PID assessments, and a printout of the HOA's county filing history showing the 7-year gap. I said, on the record, I paid the PID assessment that covers neighborhood maintenance for 9 years. I never received an HOA dues notice until this year. There is no service I was not receiving. There is nothing the HOA provided that the PID did not already cover. I received a lien for an organization I had no reason to believe was active. The judge asked Dawson's counsel whether they could show, through the association's own records, that any service had been provided to homeowners during the period between the revival filing and the lien notices going out. They could not. The HOA had collected money. It had not provided a single documented service that was not already covered. Miss Kelly made the argument clearly, in oral argument. "Your Honor, an organization that charges mandatory fees to homeowners provides no services those homeowners were not already receiving through an established government mechanism, and was constituted at a meeting that did not achieve the quorum required by its own governing documents is not a valid homeowners association. It is an attempt to collect money without legal basis. The lien should be voided, and the homeowners who paid under duress should be refunded." The judge scheduled a ruling for 30 days out. I went home and went back to work. I reconciled accounts. I corrected an error in a contractor's quarterly filing. I drank too much coffee and checked my email too often and told myself I had done everything I could do and now had to wait. The call came on a November afternoon. I was at my desk. "Ms. Eo." Kelly said my name, and then there was a pause that felt much longer than it was, and then she said the word voided. She said, "All 11 liens voided. The election was invalid. The HOA had no authority. Refunds ordered for everyone who paid." I did not say anything right away. She said, "Are you still there?" I said, "Yes, I am here. I was just sitting with it. 2 years of evenings at a kitchen table, county records portals that were not designed to be navigated easily, late nights reading Texas property law, coordinating documentation across 11 households, testifying in a courthouse, all of it compressed into one word. I sat with it for a moment, and then I said, "Thank you. Here are the numbers: 11 liens voided, 7 homeowners who had paid under pressure, awarded restitution. Metro Alliance ordered to refund those amounts within 60 days. Dawson filed notice of appeal. As of the time I am telling this story, it has not been heard, and Ms. Kelly considers a reversal unlikely given the quorum record. Metro Alliance settled the Attorney General's consumer protection inquiry without admitting liability, agreeing to require verified quorum documentation before beginning collections on behalf of any HOA client going forward. 3 other HOA communities ended their contracts with Metro Alliance within months of that settlement. The company that built its business on assuming homeowners would not look closely enough lost 3 clients when the industry found out what had happened. And the woman who was shot, she survived. She and her husband left the neighborhood some months later. I do not know where they are. I hope she is somewhere quiet, somewhere with no liens and no management companies and no men who think a gun is a legal strategy. The man who shot her was convicted of aggravated assault and received a prison sentence. I have thought about the sequence many times. A dormant organization, woken up by one person's ambition, a neighborhood that had been quiet for years split along new lines, tension allowed to build because the legal process was slow and people were frightened and frustrated and ran out of patience before the courthouse could catch up. I think about the 11 of us who waited, who hired attorneys instead of parking trucks, who testified instead of shouted, who gathered records instead of gathered crowds. We were not faster, we were not louder, we just stayed inside the system until the system worked. So now I want to come back to the question I asked at the start. If a ghost HOA appeared and attached a debt to your home title, what would you do? Because here is what I want you to actually know from this story. Your closing documents are a record. If an HOA was actively collecting dues when you bought your home, it was required to be disclosed. Its absence in your paperwork is evidence. County filing records are public. You can pull them yourself. A 7-year gap in annual reports is not a dormant organization waiting to be revived. It is a paper entity someone decided to weaponize. And if you are handed a dues notice for an organization you never knew was active, the first call is to a real estate attorney, and the second is to your state attorney general's consumer protection office. You do not have to be a bookkeeper to do this. You just have to be someone who does not accept a charge on an invoice without knowing what it is for. That is all I was. That is all any of us were. Leave it in the comments. I read everyone.